Today I'm speaking with Mark Davis from the law offices of Mark A. Davis in Pasadena, California. We are going to discuss the issue of post-conviction relief, which is a way that people can eliminate their criminal convictions if there are negative effects on their immigration status or future immigration status in the United States. Mark Davis has more than a decade of criminal law experience. He is a graduate of Stanford University and University of San Diego Law School. He is a former deputy district attorney and received one of Riverside County's Prosecutor of the Year awards in 1999. He speaks fluent Spanish, and his website is www.madlawonline.com. Mark Davis, thank you for joining us.
Good morning.
Good morning. What kind of crimes do you generally deal with in a day-to-day basis?
I get a lot of drug-related offenses.
Mm-hmm.
I get a lot of aggravated felonies. Those are cases where the sentence for the particular charge might be a certain amount that makes people inadmissible or deportable. I get a lot of domestic violence. But for the most part, I think the drug-related cases are probably the majority.
Okay. People come to my office and they say, I have an expungement. I got rid of all my crimes. Are there any immigration consequences? And I tell them, yes, most of the time there are. When is a case when an expungement would prevent immigration consequences?
An expungement is effective if you have a single offense, one offense for a drug-related crime, simple possession only, one crime only, and you completed the program without any violations of probation, and they've dismissed your case pursuant to that rehabilitative statute.
Okay, and what are those rehabilitative statute provisions called?
There's three separate statutes that can be utilized. A general expungement is under section 1203.4 of the Penal Code, and if you complete probation in any capacity at all without a violation of probation and it's dismissed, they will grant that expungement. There's another way that you can do it. It's called deferred entry of judgment. That's Penal Code section 1000. Under that particular section, what they claim to do is not enter a judgment against you. They make you plead. They don't enter a judgment. And then if you complete the drug program that they force you to do, then they will dismiss the case without ever sentencing you. Now, that's important to know because under the immigration laws, the fact that they've made you plead, it's still a conviction. But if it's a one crime, simple possession or less, and you complete the program, it shouldn't work against you, at least not on the West Coast, not in the Ninth Circuit. And the third way is through Proposition 36, and that's Penal Code Section 1210. And that's a little harder program. They actually put you on 3 years worth of probation. Once you complete that time and you do all the drug programs and you test clean and you don't violate, they will also dismiss your case under that section as well.
Now, what about people who do not have a simple possession of a controlled substance offense? They have other offenses or it's a second offense. What can you do if they come to your office?
Well, in some cases, all they need is a reduction. And so presuming that the case is something that's reducible, Penal Code Section 17B allows the case to be reduced with the discretion of the court. And as long as they have not been sentenced to prison time or suspended prison time, they're eligible for that reduction. Other cases are simply not reducible felonies, and those types of cases need to be withdrawn as if they were never pled to. And that's a little bit harder to do. People that come to my office oftentimes ask for a motion to vacate. And a motion to vacate is a situation where we have to find some type of legal error that the court made when they accepted the plea that invalidates the plea from the beginning, and then maybe we can undo it or replete it or get it dismissed.
Can you give us an example of a motion to vacate a crime?
Well, a lot of times when people come here, one of the things I'll do is I'll investigate first. I'll find out, I'll order the transcript, I'll order the plea form, I'll order the court file, I'll get everything related to the day that they pled guilty to determine if there is a basis to withdraw the plea. Ultimately, the court has to advise them of all their constitutional rights. They have to advise them of the immigration consequences of their plea. And if they don't do much of what needs to be done, or some of what needs to be done, then we can put forth an argument and try to undo the plea as if it never occurred.
What resources can people look at, if online or books, if they wanted to learn more about these post-conviction relief issues?
Resources, there's a website, Norton Tooby has a website that I think is criminalandimmigrationissues.com or something like that. You can always go to the ALA website and they will direct you in certain areas. You can go to my website, it gives you some basic information, that's madlawonline.com. But I would recommend to everyone that has an issue to talk to an immigration lawyer such as yourself, or make sure before they're even submitting papers to the immigration that they do a consultation with an immigration lawyer to make sure that the issues that they may not even be familiar with aren't going to come and bite them in the butt.
Great. Mr. Mark Davis, thank you so much for speaking with me, and I hope we could do this again.
It's a pleasure.